Hello and welcome to PDF for Exams YouTube channel. We are on the journey of revising our entire IAS Prelims 2020 syllabus once again. As we know, UPSC has postponed its prelims exam to 4th October 2020, so we have enough time and we can revise our syllabus again, and that will of course help us to crack our examination more easily than it would be in or on May 31st. So we are studying polity and today is day 4. Let's see what are the topics that we are going to cover in today's video. So in today's video we will be learning about union executives. So before starting today's topic, let me brief you out that, and we also know that India is a democratic country, and any democratic country or any democratic government can be formed in two types. It can be either presidential or it can be either parliamentary, and India forms parliamentary form of government. In parliament there are two bodies, one is union executives and other is legislative body. Legislative body is responsible for making laws or enacting laws or amending the laws which are always present in our constitution, whereas this union executive is responsible for implementation of all kind of laws that are enacted or made by legislative body of a country. So today we will be dealing and learning about union executives. This comes in part 5 of the constitution under article 52 to 78. And now let's see who are the members of these union executives. So union executive consists of president, vice president, the prime minister and council of minister and attorney general of India. So as we know, president, he is the first citizen of India and is formal head of a country. As we know, he has all the powers, but prime minister holds the main power. On the accent of president, every activities is taken place in our country. Vice president is the head of Rajya Sabha, or he presides in Rajya Sabha and is responsible for everything going on in Rajya Sabha, and whenever president is absent, vice president plays the role of president. Prime minister is not any special post, it is just the head of council of minister. He is also a member of parliament who heads the Union Council of Minister, which governs a country or which function as implementation of everything that is going in a country. And again, this Attorney General of India, he is the legal head of a country. So these are the person who are part of Union Executive. Now let's study them one by one, starting with our president. So as I said, president is the first citizen of India and act as symbol of unity, integrity and solidarity. So these three words are there in our preamble, that is, it was given that every citizen of a country should have the right of fraternity, assuring the dignity of individual and unity and integrity of nation. So this comes from the preamble of our constitution. So now coming to how our president is elected. So for this, there is an electoral college. President is not elected directly by citizen of a country. They are rather elected by representation method. Now we will see how our president is elected. As I've said, our president is not elected directly by people but by members of electoral college or by representation method. Now this electoral college consists of several members. Let's see who are those members. So those members consist of the elected members of both houses of parliament. Now parliament consists of two houses, that is Lok Sabha and Rajya Sabha. So the members who are elected, here the point to be noted is that the member in both the houses should be elected. Only they can participate in election of president, not the nominated members. As we know, in Lok Sabha we have 545 members, and out of which 543 are elected and 2 are nominated. Similarly, in Rajya Sabha there are 245 members, in which 233 are elected, whereas 12 are nominated. So these nominated candidates cannot take part in election of president, or they are not part of electoral college which are responsible for electing president. Next electoral college members are the elected member of Legislative Assembly of State. So it goes similar over here also. As we know, MLA or member of Legislative Assembly in any state, they can be any numbers. So X is the number and plus 1. So this one member of Legislative Assembly of State cannot participate or is not the member of electoral college which are responsible for electing president. The other members of electoral college are member of Legislative Assembly of National Capital Territory of Delhi and Union Territory of Pondicherry. Earlier they were not part of this electoral college, but by 17th Amendment of Act 1992, these members were also added in our electoral college which are directly responsible for electing a president of India. So these are the members in electoral college. Let's see what are the qualifications to become a president. Any member of parliament or anyone who has to become a president or who has to stand for election of president, he should be a citizen of India. So as I said, as we know, president is first citizen of India, so this qualification was very must that he should be citizen of India. It's not he, it can be he or she over here, because we do have some lady president also. At present, Mr. Ramnath Kovind is our current prime minister. Now, talking about the age, he should be over 35 years of age. Any person who is above 35 years of age can take part in presidential election along with these qualifications. The other qualification is that he should be qualified for election as a member of Lok Sabha. That means anyone who is electing for Lok Sabha, he should have equivalent qualification. Next is that he must not hold any office of profit in the government of India or any state or any other authority subject to control of any other government. That means, what is this office of profit? Office of profit simply means any job or any position which takes benefit from the government, any kind of services, money or anything. If any person is taking any kind of services or emolument or money from the government, then he holds an office of profit. So anyone electing for presidential electionship should not hold any office of profit. Now here is an exemption, that anyone who is president or these position of president, vice president, governor of state or minister of union of any state would not be deemed to be holding office of profit. That means if anyone is president and he too wants to elect for presidential electionship, he can stand, and this will not consider as office of profit. It goes similar with vice president or governor of state. That means any person in these positions can elect for president and they will not consider holding office of profit. So this was his qualification, or anyone who wants to become president, these are the qualification. Next is election, how a president is elected. So as I've already told, that president is not directly elected by people, rather they are elected by electoral college, and we have already discussed who are the member of this electoral college: elected member of Lok Sabha and Rajya Sabha, elected member of Legislative Assembly of State, member of Legislative Assembly of National Capital Territory of Delhi and Union Territory. Over here, the only important point that has to be noted is that the member should be elected, not nominated. So this was election. Now how they are elected, that means what is the manner of election, how they are elected, how any president can be elected in India. So as I said, they are not directly elected by population of India, but they are elected by system of proportional representation by means of single transferable vote, and the voting is done by secret ballot. Now over here, the point that has to be understood is representation by means of single transferable vote. Now what does this mean? So it simply means that any person, or we can say MLA or MPs who are representing a certain population of state or any region, they are responsible for electing our president, as they are the part of electoral college. And how does this work? How does this representation work? For this, there is a specific formula. So if we consider, or if we take an example of MLA, that is member of Legislative Assembly, so he might be representing a certain group of people. So if this is a group of people and he is representing, let's take an example, 1000 people. If one MLA is representing, this is just an example over here, this number is just an example. So if MLA is representing 1000 people, so the formula for his representation would be MLA is equal to total population, and that total population is 1000 upon total number of MLA selected in that particular states. So this would be an individual's representation for electoral college, and that would directly elect our president. And over here, the important factors to be considered is that this population, this has to be considered from the census of 1971. It has not taken from our latest census 2011 or 2001 or the other ones. It is considered, and this population is considered from 1971, and there is certain reason behind that. I'll try to tell you this in brief, why this population census of 1971 is considered. So if we see, after our independence, our country got independence in 1947, and this constitution got adopted on 26 January 1950. So our population was growing in certain manner. For example, if a population at this point is below here, it will continue to grow, and at some time the population explosion will start. Population explosion means growth of population at very higher rate, and after some time the population will start decreasing, and there would be a certain point. And how this population is considered? This population is considered in two ways. One is the growth rate, the other is the birth rate and death rate. So there would be a point when this birth rate and death rate would be almost equal. So, and 1971 was the time that is considered commonly that it was almost equal, not exactly equal, but it should be equal. And actually why this, the main reason behind selecting this 1971 census is that if this population explosion continues and grows too much, and there are several states in our country, so for example let's consider Uttar Pradesh, Bihar, Tamil Nadu, and if any state has more number of population, according to this population growth, there were several states who stopped their population, but there were several states who continued increase in population. So any state who are having more number of population will get more representation in election of president or any kind of election, and that state will be responsible for forming government in center or state, in center, and in its state it will obviously form the government. So this doesn't happen, that on the basis of population any state's representation doesn't increase in presidential electionship. For that very purpose, the census of 1971 was considered to be counted as population in the formula of this representation method. So this was all about manner of election. The next point that we are going to learn over here is impeachment of president. Now what is impeachment? By impeachment we understand that removal of president from his office or position, how an president can be impeached. So recently you might have heard about the news of impeachment of American President Donald Trump, although he was not impeached, but it is somewhat same, that impeachment means removal of president from his office. And why anyone can be impeached, we'll see this in this section. So this impeachment process of president is written in Article 61, which tells the procedure how an president can be impeached, and the procedure is quasi-judicial procedure. What does this quasi-judicial means? Quasi-judicial means that the impeachment process doesn't happen only in one house. If our parliament consists of two houses, that means this process or this procedure has to go through this both of the houses, then only a president can be impeached or removed from his office. Now on what ground impeachment has to be done? Now if a president is removed, president we know is the highest position of a country, and if he has to remove from his office, there should be a very strong reason or strong ground for his removal. So it is violation of constitution. How we can understand this? Why do we need a ground for impeachment or removal of anyone? We can take a simple example. For example, if you're working in any IT company or any kind of company, and your manager or boss comes and says that you are being terminated. Now if he doesn't tell you reasons or why have you been terminated, you can challenge him or you can ask him why, what is the reason that you are terminating me. So similarly, there should be a proper ground on basis of which one or any group of person can impeach president. So that ground is violation of constitution, and constitution, we know that constitution is the sole book on the basis of which the government runs the entire country. It is the book which tells us the way or method of governance, everything, laws and everything is written in our constitution. So this is the ground for impeachment. Now what is the process? What is the actual process by which the president is removed from his office? So as it is a quasi-judicial process, so initiation of impeachment of president can start from any of the houses. The initiation can start from either Lok Sabha or Rajya Sabha. So for example, a resolution is passed in Lok Sabha. It can pass from any house. Initiation process can start from any house, Lok Sabha or Rajya Sabha. So I am taking example of Lok Sabha over here, that resolution has been passed from Lok Sabha that president should be impeached because he has violated constitution. Now that resolution has to be signed by at least 25% of the members present in Lok Sabha, or we can also call it 1/4 member of the members present in that particular house. If I am taking example of Lok Sabha, then we know that there are 545 members, so it will be divided by 4, and if these many person sign on the resolution, then a 14-day notice is sent to our president that we have initiated impeachment process for you. After that, once this resolution has been passed, so from the same house that resolution has to be signed, or you can say a voting is done in which 2/3 of majority should accept that yes, the ground on which this resolution has been passed for impeachment of president is correct and president needs to be removed from office. Now once this 2/3 of majority is given, this resolution is passed to next house. What would be next house? In this case, if we are taking example of Lok Sabha over here, so the next house would be Rajya Sabha. So in Rajya Sabha this resolution is passed, and over there also voting is done and an investigation is done, in which again 2/3 of majority of house should vote to impeach our president. If this resolution doesn't get this percentage of vote of 2/3, then the president cannot be removed from this office. So this is the impeachment process of president. Now next what we are going to learn in today's video is power of president. What are the power of president? So president has many kind of power. He has executive power, legislative power, pardoning power, veto power, and many more. So let's begin with executive power, and we'll see all kind of power whatever a president holds one by one. So the very first, executive. What is executive? We know execution means implementation of the laws and acts whatever are being defined in constitution or whatever being made by the legislative body of our country. So execution means simply the implementation of everything or whatever happens in the country. So let's see them one by one what is given here. So the executive power of union is vested in president. That means whatever execution or whatever the activities are going to be held in the government for the people of India is vested with president. That means he is the supreme. The executive power does not only mean the execution of laws but by the legislative, but also powers to carry out the business of government. That means whatever the government is doing, president is responsible for that. President is head of the government. However, it is evident that the president is not free to use his power, rather he acts on the advice of council of minister. So how the system works, how this government works, we know this very well. If we try to understand with simple example of a family, of a joint family, then we can we can make a proper analogy over here how actually a president takes part in governance. So if we take example of a joint family, we can even take example of your own family. So if in your home, if your parents, you are children, you have your father and mother, and you have grandparents in your house. So if your father is the person who is earning, that means he is earning livelihood for everyone in your family, so he is the supreme power. His decisions are carried out in the family, whatever he says is done. But on the name of whom? On the name of your grandparents, because they are the senior most members present in your family. In family case, it is just because of age, but here it's not the age. But again, according to constitution, a power has been vested to the president as the senior most or the first citizen of country. That's why all the executive powers are vested to a president, and he may or he may not use them freely. There are few powers which he can use freely, but there are most of the power he has to take advice from council of minister. Now who are these council of minister? There are certain ministries in a government like finance minister, railway minister. All departments have several ministers, and these council of ministers are headed by prime minister. So prime minister is not a specific post but head of the council of minister who are governing a country. The executive power of the president includes administrative power and military powers. Here is important that military powers are also vested to a president. Administratively, the president may not discharge any function as there are ministries responsible for such act. That means administratively, that means in the proper hierarchy, if you become an IAS, you will be heading a district and you will take decision for everything happening in your state, but you will directly not go and do any activities. You will ask certain departments to do those activities. So similarly, president in administratively or in administration does not directly discharge his duties or function. It was just an example here. IAS may go and discharge some function, but in case of president, he doesn't go and discharge his function directly, but he takes help from the responsible ministries and all the activities are discharged. So in this way, the president becomes a formal head and action is taken by his name. As I told you, as I gave the example of family, that every action in your family is taken on the name of your grandparents. So similarly over here, every action is taken on the name of president, but it is done by the council of ministers from every department. What are the other power of president in terms of execution? Here the execution power also involves appointment of several dignitaries. That means there are several positions or posts in Indian government which are appointed by president of a country. So the president shall have power to appoint Prime Minister of India. Now see, over here it is written that president appoints the Prime Minister of India, but does it actually happen? Actually what happens, the majority party, for example two parties are electing from Prime Minister candidate or for forming the government. We know the election very well how it happens. So if two parties are fighting for forming government in center, so the winning party or the party with majority of votes will form the government, and head of that party will be considered as prime minister. Here president has to appoint the head of the ruling party as prime minister. Other minister of union, now as I told you, there is a union of our union council of minister which are responsible for governing our country, which are appointed by president. But here an important point is that he has to take advice from the prime minister, as prime minister is the head of the ruling party. The president is also responsible for appointing Attorney General of India. Attorney General, I have already told that he is the head legal advisor of the country. President is also responsible for appointing Comptroller and Auditor General of India, judges of the Supreme Court, judges of High Court and states, judges of High Courts of state, governor of a state, a commission to investigate interference with water supply, financial commission, UPSC head. Many positions are there in which government can appoint anyone he wants, but not actually he wants. He has to consult responsible group in that. If president has to appoint union of minister, he has to take suggestions from prime minister. If he has to appoint Supreme Court judge of High Court, he has to take concern, or he has to concern with Chief Justice of Supreme Court of India. Similarly, it goes with all these positions. Next is the president shall also have power to remove. So president can remove few dignitaries from post. For example, he can remove Attorney General of India, Governor of State, Chairman or Member of Public Service Commission of Union on the report of Supreme Court. Now here, as I told, there are certain restrictions for him to perform his activity. Now if he has to remove Chairman or Member of Public Service Commission of or Union or State on the report of Supreme Court, that means Supreme Court will make a certain report. On the basis of that report only president can remove dignitaries from these positions. Then next is judge of Supreme Court or High Court or election commissioner on the address of parliament. Now again, if a judge from Supreme Court has to be removed or impeached, then here the parliament is the sole functioning body over here who will, or on whose suggestion president can remove dignitaries at these positions. So these all were the executive power of a president. Now moving to next, legislative power of president. What are the legislative powers? So legislative simply means forming of laws, or the body which forms laws. What are his roles in those bodies? So he has power of summoning, prorogation or dissolution. That means if any session is going on, for example Lok Sabha or Rajya Sabha session is going on, so he has power to disclose or close those sessions without any information, or if he finds any deadlock between them, like House of Parliament like Lok Sabha and Rajya Sabha, if there is any deadlock or anything, he can summon those houses. He has power of opening address. That means whenever a new government is formed in both the houses, Lok Sabha and Rajya Sabha, he start his speech. He can give his speech and tell the idea, or he can give idea about summoning, what happens if summon is done. Next is right to send message. Apart from the right of address, he can address this Lok Sabha and Rajya Sabha, and he can also send messages whenever there is any pending bill or any kind of matter, whatever has come to him for his assent. What is the next power? Next power is nomination of member to the houses. And as I've already told that in Lok Sabha and Rajya Sabha there are several nominations done. In Rajya Sabha 12 nominations are done, in Lok Sabha 2 nominations done, and these nominations are done on the basis whenever the parliament or president feels that a particular group of people have not been represented properly in the election, then these members are nominated by president in Lok Sabha and Rajya Sabha. Next is laying report before parliament. So the parliament, president is brought into contact with parliament through his power in study cause of certain report and settlement to be laid before parliament. So parliament may have opportunity of taking action upon them. So any kind of report which has come in front of him, he can he can present those reports in front of parliament so that the parliament can take particular action whatever is required. Next is previous sanction of legislation. The constitution required previous sanction of or recommendation of the president for introducing a legislation on certain manner. That means if any new act or any new law has to be enacted, so president consent is always required. Next is assent to legislation and veto. Veto means denying. So as we know, for forming any laws or enacting any laws or doing any kind of amendment, whenever those acts or bill has been passed by both the houses, any bill until and unless given accent by a president doesn't become an act. So for example, if an act or a bill, a bill is passed by Lok Sabha, then that bill is passed by Rajya Sabha, it comes to president. Now president, it is up to him whether he wants it to become a law or not. If he assents, if he gives his assent, then it becomes a law. If he doesn't, it doesn't become a law. Although there are certain criteria that in some cases he has to give his assent whether he wants or not. So what happens, so he has the power of veto over here. So whenever any bill reaches him, he has the power or he has option to give his assent to bill. That means at the first time itself he gives assent to his bill and that bill becomes an act. Next, he can withhold his assent to his bill. That means whenever a bill comes to him, he can withhold and tell them or ask them to make certain changes, and after that only he will give his assent to that bill. In case of money bill, return for consideration is not allowed. That means any money bill comes to him, he has to give his assent. And similarly it goes for amendment of constitution. Any kind of amendment in any law is required, then at that time president has to give his assent. Assent. Now we'll see what are the types of veto power he has. So this veto power is discrete in nature. That means it's not absolute. So there are certain kinds of veto. What are these veto? Let's see them one by one. The first is absolute veto. Absolute, by the name itself, it is understood that if any bill come to him, he can just directly refuse that I won't give my assent, I won't sign to this bill, so that it becomes a law. So this means by absolute veto. Next is qualified veto. A qualified veto, when it can be overridden by higher majority of legislator and bill can be enacted as a law with such majority vote overriding the executive veto. That means in some cases what happened, a bill is passed by both the houses and sent to president. The president sends it back for reconsideration, but again if both the parliament passes that bill again without any changes, then president has to give his assent. Next is suspensive veto. Suspensive veto, what it is, let's see. A veto suspensive when executive veto can be overridden by legislator by ordinary majority. Next is pocket veto. Pocket veto means by keeping the veto for small time of time. For example, as I said, that president has power to hold the bill with him and ask them to make some changes, or sometime he can hold the bill and doesn't inform to parliament that after how many times or after how much time he will give assent to the bill. But here in pocket veto, he has to give his assent by after a certain days of time, or he has to say that after this much time I will give my assent. Why I'm saying this accent. Next is ordinance issuing power. Now what is this ordinance issuing power? Ordinance means any bill becoming act. Similarly, generally what happens for making any laws, a bill has to be passed or introduced in both the houses. Once they are passed in both houses, after that president gives his assent and then assent, then that bill becomes a law. But in some cases, in case of emergency, what happens when this sitting cannot be done in any kind of houses, in that case president can directly pass an ordinance which can become an act, and it will act equally as a normal law which are being made in parliament. So this is known as ordinance issuing power of a president. Next power is pardoning power. What is this pardoning power means? Pardoning power means if there is any criminal or anyone who has got or who has been punished by court or legal system of India, so here president gets the power to reconsider the case, and if any mistakes are being done in legislative system, so here is an option to correct it. So what are these powers? So first of all, let's see that this pardoning power has been enacted or written in Article 72, which grants pardon to a person who have been tried and convicted of any offence in all cases where the punishment or sentence is for an offence against union law, offence by court martial, and sentence to death. That means any kind of punishment that is given in civil court or even in military court, that is any court martial of any soldier, or he has, or any in civil court anyone has been given sentence to death, then at that position or at that time president has power to pardon his or whatever the punishment has been given. So here there are several kind of pardons. Let's see what are those pardons. So first is pardon. Pardon means it removes both the sentence and conviction and completely absolves the convict from all sentence, punishment and disqualification. That means anyone who is in jail serving his punishment can be removed, all the punishment can be removed from him and he can be set free. The next is commutation. Commutation means substitution of one form of punishment from a lighter form. For example, if anyone has got a punishment of hang till death, then that can be converted to lifetime rigorous imprisonment, or if anyone has got a punishment of rigorous imprisonment of lifetime, the time period of that imprisonment can be decreased, or that imprisonment can be converted to simple imprisonment. So this is mean by commutation pardon. Next is remission. Now what does this remission means? It implies reducing the period of sentence without changing its character. Now in case of commutation, even the character of punishment could be changed, but here what happens, if someone has got rigorous punishment imprisonment for 7 years, and that rigorous imprisonment can be decreased to 2 years. That means time can be changed, but the nature of punishment cannot be changed in case of remission. Next is respite. What does it denote? So it denotes awarding a lesser sentence in place of one originally awarded due to some special facts such as physical disability or convict or pregnancy of the woman offender. Now here what happens, let's take an example of a woman who is pregnant and she gets an imprisonment of 1 year. So this time can be reduced over here. Last kind of pardon system is reprieve. What does this mean? It implies a stay of execution of sentence, especially that of death. That means if any person has been given a punishment of death, then that can be stayed for some time to reconsider in other courts. So this is what we call as pardoning power of president. At the end and last power of president is emergency power. What are the emergency conditions? We know there are 3 kind of emergencies present in our constitution for our country. One is national emergency, other is state emergency, and the last is financial emergency. Till now there has been no financial emergency, but there has been national emergency, and the most important and most renowned national emergency is in 1975 when Indira Gandhi was in power. So what does an president have emergency power? So here a president enjoys emergency power. In a federal structure, the grip of union on the state is not so tight, and hence constitution framer did provide an exigencies which may require to tighten up union and state. So what does this statement means? This statement simply means that in federal form of government, as we know in India we have federal form of government. Federal means we have parliament at central level, and we have legislative assemblies at state level. So if state levels and this central level does not have good relationship, so there can be problem in running a country. Or if they have a separate power, they can frame their own country and they can be a separate country. So this doesn't happen. So for that case, Indian constitution have appointed governor in each state, and that governor helps in case of emergency conditions. So for example, if a governor finds that the state is not able to perform their duties well, or they are not forbidding, or they are not following the constitution, or there is some external insurgency in that state, so over there a governor can call president and ask him to take ruling position in that state, and that would be called a state emergency. So over here Article 356 gives a special power to president for existence of his rule in state if the president on receipt of report from government of state or otherwise is satisfied that the situation has arisen in government of state cannot be carried on, president may extend his rule to state. This I have already explained. Next is Article 360 deals with financial emergency. Financial emergency has not been existent till now in India. At least in India there has been no financial emergency till now, but in case if there is a situation required that India needs a financial emergency, we can take a very big example of present scenario. For example, in coronavirus pandemic, if there would require a financial emergency in this condition that everyone was suffering from finances, then here president could allow financial emergency in our country, and this power was given to president. So this was all about president. Now moving to the next executive member, that is vice president. Vice president So by the name itself, it is clear that Vice President occupies the second highest office in the country. First is President and second is Vice President, who is second highest office in the country. Now, office is modeled on the line of American Vice President. As we know, our Constitution has taken several parts from different countries. So here, Vice President office is modeled on the basis of American Vice Presidentship. So what is the tenure of Vice President? It's 5 years. But if Vice President wants, he can resign his office at any time by addressing the resignation letter to President. So whenever he wants, he can apply for resignation with the President. And a formal impeachment is not required for removal. As we have seen, for removal of President, there is a big procedure for impeachment of President. But if anyone wants to remove Vice President, not anyone actually, the complete parliament or the complete government wants to remove Vice President, there is no official process for removal or impeachment of Vice President, or it's not required at all. He can just be removed by resolution of Rajya Sabha passed by an absolutely majority, that is majority of total number of House, and agreed by Lok Sabha. That means, and why Rajya Sabha over here? As you know, President is part of Rajya Sabha. So if majority of Rajya Sabha wants to remove the Vice President, they can do by passing a resolution of majority, and once it is agreed by Lok Sabha, Vice President can be simply removed. And there is an important fact over here: Vice President is eligible for re-election. It's not that once Vice President is become, he cannot apply for Vice President again. He may be elected for any number of time. Now next is election, how a Vice President is elected. So it is almost similar to how a President was elected. Vice President, like President, is elected not directly by people but by method of indirect election. How does this indirect election takes place? This indirect election takes place by electoral college. But the difference from the President over here is that in case of President, we saw that the members of electoral college were only the elected members of the parliament and member of legislative assembly. But over here, it is said that it consists of both elected and nominated members. This is the only difference, that in case of President, only elected members were responsible over there in electoral college, but here both elected and nominated members of parliament can be member of electoral college. And it does not include the member of state legislature. And this is one more difference over here. In case of President, member of state legislative assembly were there, but here they are not. In case of President, we have seen that member of state legislative assembly were included. So this is how an election of President is done. Now let's see what are the qualifications. So again, these qualifications are same as it was in case of President. He should be citizen of India, he should be completed age of 35 years age, and here he should be qualified member for election of member of Rajya Sabha. In case of President, we had Lok Sabha. The last part or last qualification is that he should not hold of any office of profit under the union government or any state government or local authority or any public authority. So over here, if a Vice President is holding any of these positions and he wants to be elected as a Vice President, then he has to give resignation from these positions, or whatever office of profit is holding, then only he can apply for Vice President electionship. Now what are the conditions of his office? So the condition of his office are that he should not be a member of either House of Parliament or a House of Legislative. If any such person is elected Vice President, then he is deemed to vacate the seat. This I've already told. And the next is that he should not hold any office of profit. These conditions I've already discussed. Next is function of President. Let's see what are the function of President or how Vice President functions. So he is chairman of Rajya Sabha, and normal function of Vice President is to preside over Rajya Sabha. That means whatever function is going on in Rajya Sabha, Vice President is responsible for that. And in case of absence of President, as I have already told, that if President is absent or he is removed by impeachment or he is ill or he dies in between of his tenure, then Vice President is the one who is responsible or who acts as President during that time. And the vacancy may occur, and this I've already discussed. And he is not member of Rajya Sabha. He has no right to vote, but can exercise a casting vote. And one more important point over here is that Vice President is not a member of Rajya Sabha, but a part of Rajya Sabha, as he is chairman of Rajya Sabha, and he has no right to vote, but can exercise casting vote. And next point is that vice president shall, during in respect of period while he is acting or discharging function of president, have all the power and immunities of president and entitled to such emoluments, allowances and privilege as may be determined by the parliament law until provision in that behalf is made such emolument, allowances and privilege as specified by second schedule. That means whenever vice president is acting as president, so vice president will get all kind of facilities including monetary benefit whatever president gets during the tenure of his acting as president. The last function of vice president is that when he acts as president, he will not draw salary of chairman of council state as he ceases to perform these duties as chairman. Again, this is not a function, this is a part. Whenever a vice president is working as president, he can just take one salary as he is not able to discharge his duty as chairman of Rajya Sabha since he is acting as a president. So this is all about the vice president. The next very important member of union executive is governor. Now what is this governor? So governor is simply the head of state. How So governor is simply head of the state, as president was head of a country and governor is head of the state. It is written in article 153 to 167 of part 6, which deals with state executives, and state governor is the head. So what are these points? Let's see them one by one. The state executive consists of governor, the chief minister, council of minister and the advocate general of the state. Till now, till vice president, we have been studying about the executives at the center. Now we are studying about the executives at state level. So at state level, governor is the head and we have council of minister here again, as there it was in center, and at central level prime minister was the head of council of minister. Here chief minister is head of council of minister. And there earlier in each state there was one governor, but after 7th constitutional amendment of 1956 it facilitated that one governor can be appointed for more than 2 states. Now what is difference between governor and president? In president we saw that there is election procedure for president. That means president was elected either by indirect method, but yeah, he was elected. But in case of governor, governor is not elected. He is appointed by president under his hand and seal. That means president is the one who is responsible for appointing governor at every state. And tenure for a governor is 5 years. That means after the date when he enters his office, he can function as a governor for that state up to 5 years. And of course he can always give his resignation to president whenever he wants, and a governor can be always removed with the president consent whenever required. So this is about governor. Now we'll see what are the powers and function of a governor. So first we will see the executive power of a governor. So governor being the head of the state executive, all executive action is expressed to be taken in the name of governor, very similar to the president over here. He was head of the country, so every executive action taken at the central level was taken in the name of president. Over here it is taken on the name of governor. So as president has power to appoint several positions, over here again governor has power to appoint several positions or several offices. So he can appoint the chief minister and other minister. At central level, president was appointing the prime minister and other council of minister with the help of prime minister. So it goes similar over here. He has power to appointing advocate general, chairman and member of state and public service commission. Over there it was union public commission, here it is state public service commission. Next is member of subordinate judiciary, that is district judge and court below. This president had power to appoint judges of Supreme Court and High Court. Over here governor can appoint district of judge and below, but with consent of president. Next is vice chancellor and state universities. So any universities running under aiding of states or it is being funded by state, so governor can appoint vice chancellor. He has to appoint the vice chancellor of that university, whereas the chancellor, governor himself, is considered as chancellor of those universities run by state. So these are the executive power of governor. Now let's see what are the legislative power. So the governor is the part of legislator according to article 168. In this capacity he performs many functions. What are the functions? Again it would be almost similar, but there would be little difference from what was there or what was the legislative power of the president. So he can summon, prorogue and dissolve the legislative assembly. Over there he could dissolve, in case of president, he could dissolve the parliament assembly. Right to address the legislator and send message to it. This is very similar to the power of president, but at state level here. Just remember one thing, president can do anything, everything at central level, and here the governor is doing everything at state level. No bill can become law unless governor gives assent to it. Again similar. He nominates one member of Anglo-Indian community to state assembly and 1/6 of the member of legislative council from among the person having special experience in arts, science, literature, social science. So here governor has option, or he has power to appoint the Anglo-Indian community one member in each state. So this is the legislative power of a government. Next is assent to bills. Now here again it would be mostly common how it was in case of president. So let's see what are these assent to bill power. So when a bill has been passed by legislative of a state, it shall be presented to governor, who may accept or reject the bill. So here the point over here is that he has the power to either accept or reject a bill. In case of bill other than money bill, he may return to the legislature for reconsideration. So if it is not a money bill, because money bill has to be passed by governor or president whenever they receive such kind of bill, but apart from these bills, any bill can be sent back to legislature for reconsideration. Next is governor may also reserve the bill for reconsideration of the president. For example, if governor wants to seek help for consideration from president, then he can keep the bill, and whenever he gets the assent from president, then he can approve that particular bill. When a bill is returned to legislature by a government, it must be passed again to be accepted by the governor. This point is also common in case of president. When a certain bill was not accepted by president and it was asked for reconsideration, then and once again when it was passed by both the houses without any changes, at that time president has to give his assent to that bill. So it goes similar over here. In essence, as per Article 200, when a bill passed by legislator of state is presented to governor, he has 4 options. Now what are these 4 options? Whenever bill is presented to a governor, he can give assent to the bill, and that will ultimately become an act. He can withhold the assent, that means he can withhold for some time, or he can give it the bill for reconsideration. He will give the bill to legislature so that they may reconsider it and make changes. After that, that will become a bill. He reserved time bill for consideration of president. This has already been explained earlier. So these are the power of bills. Now what are the bills that has to be considered? So let's see that in Article 201 it has been explained that when a bill is reserved by a governor for consideration of the president shall have declared either that he assent to the bill or that he withhold assent in case of money bill. So over here president gives his suggestion as per requirement. In other bills, he may return the bill for repassage, the third option for the president. Next is the repassed bill need not to be assented by the president, and he may return again and again. Thus it will have an absolute veto. There was a power of absolute veto to a president that if he want, he can directly reject the bill, and that would never become an act. And there is no time limit within which the president should take the decision. This time limit for president is unlimited. That means if any bill has been presented to him, he can take whatever time he wants to give his assent. There have been instances where bills have been pending with the president for a period up to 6 years or more. So see, this time there was certain bill when governor seeks or whenever he needed help from president, then president kept that bill for more than 6 years to give his assent. So these are the bill reserve consideration. Next is financial power. So let's see what are the financial power of a governor. It is he causes to be laid before legislature and annual financial statement. Money bill cannot be introduced in state legislative assembly without prior permission to governor. That means any kind of money bill which has to be introduced in legislative assembly, permission has to be sought from the governor. Next is annual and supplementary budget are introduced in assembly in the name of governor. Any kind of budget that may be annual or supplementary is always presented in the name of governor in legislative assembly. No demand grant can be made except on his recommendation. That means any change cannot be made apart from his recommendation. The governor has the control over the state and contingency fund. Without his assent, the fund cannot be drawn upon. Any funds coming to the state for welfare of the state, it is our governor consent is needed for that fund to be used for any kind of purpose in the state. So this was his power. Next is judiciary power. What are the judiciary power of a governor? So he is consulted by the president while appointing judges of state court. So for example, as we told, the president has the power to appoint Supreme Court judges and state high court judges. So if a governor belongs to a certain state, president may seek his consultation for appointing high court judge. The other judicial power of governor include pardon, reprieves, respite, remission, commutation. So these are similar the power vested by the president. That means according to pardon, he can completely absolute offender from all punishment. That means anyone who is being punished of any kind of punishment he has given, so governor can give him pardon or set him free, and he would not be punished in any situation. The other is reprieve, stay on execution on sentence of temporary period. That means if someone has been sentenced, so that time limit or that execution can be given stay for a certain period of time. Next is respite. It is similar, that avoiding lesser punishment on special grounds. If there is some special case, the punishment can be reduced than what actually was given to that individual or any person or any criminal. Next is remission, reduction of sentence without changing its character. That means if a person has been given a 7 years rigorous punishment, that can be reduced to 2 or 3 years of rigorous punishment, but that character won't be changed. Whatever the character of punishment has been given, only the time limit can be changed, but the character or nature cannot be changed. Next is substitution of one form of punishment to another form. Over here, commutation simply means that if someone has got punishment of hang till death, that punishment can be converted to life imprisonment. So this is comes under commutation. Next is discretionary power of governor. So these discretionary power of governors are that under 163 there shall be council of minister headed by chief minister to aid and advise governor, and governor can exercise his power according to such advice except whether the constitution requires him to act in this section. That means in legislative assembly there should be council of minister, of which chief minister would be head, and they would advise governor to function or do all kind of activity that's required according to constitution for that particular states. There are two types of situation in which governor is expected to use his discretion power, and those are implied by nature of parliamentary democracy and constitution, and the other is in which constitution has expressively imposed special responsibility on the government. So whenever parliamentary democracy is required, or else if any special responsibility has been given to governor, in that case discretionary power of governor can be used by him. So these are discretionary power, and there are some special power given to governors of separate state. We will not see this. And last is prime minister. So let's see what is prime minister. So as we have seen that prime minister is head of union of council of minister that is formed by the majority party which wins the election. Over here article 75 provides that the prime minister shall be appointed by president. It has already been told in the beginning, but the president has no choice except to appoint prime minister, the leader of the party which has absolute majority in Lok Sabha. This has also been told in the beginning, that the member or the party which is winning or has the majority, the leader of that particular party is elected by president as prime minister. So this is all about today's video. We have learned about union executives and members, their powers, their process of election, the impeachment. So this is all about day 4. See you in next video, that is day 5. We'll learn about legislative council. Till then, goodbye.